But for them to say, oh, you should be ready in 2 years. I've spent 2 years on this already, and I've only got 1 file, 2 close, and I have 14 total to do. So it's not so flippant. It's not so easy. The petition process that the city offers, which a lot of people have talked to me about, originally I had heard that it was only going to be good for 10 years. Then I understand it's 20 years. Is that correct? 40 years? Okay. So I said, okay, 10 years is not going to be good, 20 years is not going to be good. I always go back to the parking in the yard ordinance that I went around and got us to opt in. And then trying to get it enforced is just brutal. Just the police department says, well, the owner owns that car in the house. That doesn't have anything to do with it. So we go back and forth, and they finally go over there and get the car moved. So I'm concerned about the enforcement being thrown back on me when there's a problem going on. And when you're dealing with developers, they've got a lot of money, they've got a lot of connections to the planning, and a lot of things can move real quick before you can find out that, wait, this would pass what it's supposed to have gone, and you're trying to get it to double back. I would say it's almost near impossible. But so I appreciate what you're trying to do. I'm just saying 2 years, my stomach just turned. There's no way I can finish this in 2 years. I mean, I beg for volunteers. We have newsletters that go out. We have signs that get posted. We have people that walk door to door. I have flyers that go on doors. I have postcards that get mailed. And here I am. So that's all I need to say.
Okay, we're not talking about anything here today that has to do with deed restriction, renewal,
right.
Or it's a completely different process.
Right. But we don't have
a very different legal standard. And Chair recognizes Councilman Lassiter.
Actually, I'd like to just thank you for pointing out how difficult a deed restriction regime change can be and how long it can take. Because in looking at adding a neighborhood protection level of up to 500 homes to be able to opt into this protections for the minimum lot size, we wanted to make sure that it was outside of the context of a deed restriction requirement. This process is designed, hopefully, to be easier because it is not within that deed restriction regime. So we understand how difficult it can be. So thank you for educating us again.
The reason why I'm doing the deed amendment is because we don't have a minimum lot size. We don't have that structure. The deeds are like 1950 something.
And that's my point.
So I have to.
This new proposal would allow you to get a minimum lot size requirement for your neighborhood outside of the deed restriction requirements. So arguably, that should be much easier for a neighborhood to approach. I'm not going to say it's going to be totally easy, but it's supposed to be easier in practice.
Is it a notarized signature that you need?
I'll let you speak with the, I'm hearing from the Director of Public Works, Planning Department, no. So
It's not a notarized? That's
The owner of the property has to sign, but it's not a notarized signature.
And how do you, are you verifying who's, because I get a printer to sign.
I don't want to take up step on the council member, but the short version is, it's not, deed restrictions are a compact among the citizens. You are choosing, this is a process that council votes on, so in a legal sense, it doesn't matter if there's one person who signs or 100% of people who sign. It is the vote of council that creates the minimum lot size and the minimum setback.
Mayor, I just encourage you to visit with Marlene Gafford about this. You may be pleasantly surprised about the process.
I understand the notice I got back for this meeting says that Chapter 42 will not affect a neighborhood if they have deed restrictions, but that wouldn't be true if you don't have minimum lot size or setbacks, right?
It would, Chapter 42 itself will not affect a neighborhood with deed restrictions. The only way, you would have to affirmatively choose to put in the minimum setbacks and the minimum lot size. So just the passage of the ordinance will do nothing to your neighborhood. If your neighborhood chooses to go forward, you have the opportunity to add that outside of the deed restriction process.
I'm confused. Are you saying that I cannot have a minimum lot size or setbacks and they cannot do this?
If you have minimum lot size and setback lines in your deed restrictions, it won't affect you at all. We cannot take an action here that will override your deed restriction.
But we don't have
If you don't, then once we pass this, you can go through the process of adding those, but you don't have to change your deed restrictions to do it.
Oh, I understand I don't, but I also understand the deed restrictions would trump anything. Also, when you go to pull a permit to do building, which my husband and I, we build residential construction, the deeds always appear. I'm worried about 42, what will serve, or even deed restrictions sometimes don't appear. But I feel like I have a better chance at it.
We maintain those records here within the city.
Okay.
There are a couple of Councilmember Brown.
Thank you, Mayor. In addition to the minimum lot size, the specification of the deed restriction would be beneficial for the non-subdividing of plats, and so there are other concerns certainly out there. I think that deed restrictions are better to have, obviously, than the process that perhaps is being proposed, but in lieu of, hopefully this will be working for the neighborhoods. The question, I've gotten conflicting information, so I want to pose this question to the administration, is after the 360 days, that is what we're talking about for this process to go and apply and get the minimum lot size for your neighborhoods, after the 360 days, can subdivisions, civic associations or whatever, subdivisions, can they change their deed restrictions after the 360 days and put in those minimum lot sizes, or will that no longer be a valid because it will be in contradiction to the new city ordinance?
Deed restrictions trump.
Even if you make changes after the fact?
Correct.
Which is why I would seek to change the deed restrictions. Mine don't expire, so once I get that in, I'm in. There's no 10-year, 20-year, 40-year. And then defending it is a lot easier in court than trying to defend something else. Because the state trumps city, usually.
Because I got conflicting information, and after an ordinance is passed, that's the law, even though the deed restrictions that are being proposed to come into the neighborhood and be approved are in contradiction to that ordinance, it's still a risk.
And I'm not the city attorney, you will wave at me if I go astray, but existing deed restrictions trump. We would not initiate the process in a neighborhood that has deed restrictions that deal with minimum lot size and minimum building lines. We can impose it on a neighborhood, and if that neighborhood wants to amend its deed restrictions later, they can do something that is more stringent than what we have, but that is a private compact among the residents, and so it still trumps.
Yeah, I hope I'm not being misunderstood. My question is, after 360 days, can a neighborhood initiate the process to change the deed restrictions to be in conflict to the city ordinance of protecting the minimum lot size and the like? They
Yes.
can? Okay.
I mean, deed restrictions is a process completely separate from anything we do, and they can go beyond what we choose.
All right, thank you for the clarification.
Council members, Councilmember Green.
Thank you, Mayor. Mayor, a couple of questions in administration to the administrator with regard to first question, notice, because it's not filed with the county, how will a builder be put on notice that perhaps that this particular neighborhood is exempt from Chapter 42?
This is all through our permitting process.
Okay, so before they get permitted, it'll be screened and we'll be able to catch it. Second, if a deed restriction has lot size but doesn't have setback, and the neighborhood wants to apply, will they be able to do that? And if a neighborhood wants assurances, is there a way a neighborhood can get some sort of assurances from planning that their deed restrictions are in effect and the new Chapter 42 would not be applicable in their area?
Okay, minimum lot size and minimum building line are two separate items. You don't have to do both. Do one or the other.
So in the application process, they would only, if the deed restriction didn't speak to it, they could only apply to where it was
They
not.
can fill the gap, whichever one that was.
Okay.
And the other part, and I don't know what other
I
assurance we
just-
can give.
Well,
I mean,
there's some
deed-
protections that
deed restrictions
this-
trump.
right, but there's some protections that we have here that maybe the neighborhoods don't have. And so by them opting in, going through the application process, they may have additional protections.
The only protections that are minimum building line and minimum lot size.
Okay,
And
so
the reason we-
subdivision and
The reason we passed those originally was to protect, to give a tool to those areas that did not have deed restrictions or were in areas where deed restrictions were lapsing. Because it is a cumbersome legal process to reinstitute deed restrictions, and so this was processed outside of that.
Okay, thank
It's
you.
sort of a backstop.